Welcome everybody, my name is Jeff Fowler, President of the Apartment Owners Association, and today we're going to be covering the new San Diego Tenant Protection Ordinance that's been put in place. And this is complicated, and I'm really glad that you found this video and that you're able to watch it. And the Apartment Owners Association, we've been around for over 40 years, and we serve all of California. We are fully supporting San Diego. We have the forms that are needed for the lease agreements, for even with this new ordinance. We have the recycling addendum as well. And so all those things are in place. We have our office on Camino del Rio, and Victoria is there pretty much 8:30 to 5 every day of the week except for Fridays. She's half day on that day, but we are here to serve you whether you're in person or not. We have just about monthly meetings, and so you can catch the next one. We're going to be having Pacific Legal Foundation come in and speak, and usually it's eviction attorney, someone like that speaks for us. And anyway, again, it's great to have you with us today. And just looking here. So just about our speaker today. He's been a resident of San Diego since 1970. He has 3 degrees from the University of San Diego, and he's actually an adjunct professor there for over 20 years. He's a real estate contract law, and he also does resolution of contract disputes. And so more than just an eviction attorney, but he has done over 9,000 unlawful detainers. He's the founder of Simone and Blevins, the Landlord Legal Center. And so it's my pleasure to go ahead and introduce this video with our featured speaker, Franco Simone.
Welcome everybody. I'll try to speak as loud as I can. So just to fill in a little bit of the gaps, I've been an attorney here in San Diego County representing landlords for the last 30 years. So I've been in this business for quite a while, and I understand the pain that you guys are going through. I also own some properties as well, so I'm on the ownership side as well. So what we're going to do today, I want to thank Victoria and AOA by setting up these meetings. I really do think it's important that people try to educate themselves the best they can on these laws, because it will help make your life easier. It will help make your tenant's life easier if everybody can kind of understand what everybody's responsibilities and duties are. So it's good that you're trying to educate yourself, and that's why I do these events as well, because I want to make sure that landlords understand what the law is, because in my experience, landlords want to follow the law. They want to do the right thing, and so by educating them about what is the right thing, I'm actually hoping that I'm helping you guys to make sure that you guys do the right thing. So this new law, and we're going to just be focusing on this today. Let's move on. So basically, this new law was passed in June 24th, 2023, okay, and it's called the Residential Tenant Protection, and that's the ordinance number. And basically, this law replaced the Tenant's Right to Know ordinance that was enacted in March 2004. So that Tenant's Right to Know ordinance no longer applies. It was replaced by the new law that we're talking about today. Now here's just a quick chart showing what the differences are between the old law and the new law. The old law basically only applied after a tenant was there for 2 years. Currently, the protections start day 1, okay? Also, we're going to be talking about 3+ tenancies later on at the end. So this new law starts day 1. So as soon as a tenant moves into your possession, it may apply to your tenant, depending on certain exemptions. Also, in the old law, there was no relocation benefits. Under the new law, there could be up to 2 to 3 months that you pay in relocation benefits, and we'll cover those. In the old law, it applied to basically all houses and condos. In the new law, it exempts certain houses and condos, and we'll be covering that. In the old law, there was no regulations dealing with buyout agreements, and buyout agreements, people also know those agreements as cash for keys agreements. So under new law, there's certain regulations now you have to follow if you want to try to do a cash for key agreement. And basically what a cash for key agreement is, you go to your tenant and say, hey, look, I want you out, and why don't we just come to some agreement? If you move out on a certain date, certain time, I will give you X amount of money, or I'll waive X amount of rent on your behalf. So those agreements now are going to be regulated under the new law, which they weren't under the old law. And in the old law, there was no notice requirements. In the new law, there's going to be notice requirements. So under the new law, there's certain exemptions. Okay, so I'm going to go over the exemptions to see whether or not your particular property this law is going to apply to. Okay. Oops. So the first one, and I'll go through this quickly, this law does not apply to hotel occupancy, short-term residential occupancy, basically like Airbnbs. It's not going to apply to certain properties or deed restrictions, meaning they receive certain federal tax credits. And if they receive these certain federal tax credit, then the federal law applies, a city and state law would not apply. And they're usually, if you own a tax credit property. So if you don't know what that is, then you probably don't have a property that deals with a deed restriction. The other one, a D, is basically you're getting special subsidies from the federal government to provide housing for very low and moderate income people. It doesn't apply to mobile homes. It also doesn't apply to religious, hospital, special care facilities, senior care facilities. Also doesn't apply to dormitories. Now, exemptions, some of the ones that might apply to units that you may have. If you own a property and you're the landlord and you live in the property and you share a bathroom and a kitchen facilities, then that property might be exempt. So let's say you own a home, you rent out a bedroom or two, that property is going to be exempt from this law. Also, it includes single family residence, okay? So basically, if these two following requirements apply, then this new law does not apply to you. So basically, you rent or lease out no more than 2 units or bedrooms on the property, and that includes a mobile home. So what does that mean? You could have a single family house as well as an ADU, an additional dwelling unit on the property. And if you lease out either the house or the ADU no more than 2 other tenants, then you may be exempt as well. And that might include if you have a mobile home on the property. Okay, so basically an example is the landlord lives in the main house and he rents out an ADU. So you live in the main house, you rent out the ADU to someone else, this law, you will be exempt from the law. Okay, another exemption is basically a duplex. This is on the bottom, J. Duplex where the landlord occupies the other unit as their principal unit. So duplex, you have 2 units, you're living in one, the other one you rent out, this law would not apply to you. This is a big exemption. If the building is a new building, meaning you got the certificate of occupancy, which is basically permission from the city that someone can live in this structure, and it's less than 15 years old, the law does not apply to you. Okay? So if somebody goes out there, builds 8 units, for the first 15 years of the life of those units, the law will not apply to you. Also, you'll notice on the very top, it'll have the section number of the law, 98.0703, and also that page number, page 9, refers to, if you actually look at the law, if you download the law, it's roughly about 25 pages long, it's giving you a reference exactly where I'm getting this information from. So if you download the law, on page 9 of the actual ordinance, you will see this exception, and the exception will be labeled as subset K. Does that make sense? So it'll make it easier when you're looking at this. If you have a copy of the law and you're looking at this, it's like, well, what is Franco referring to? Well, go to that page 9, you'll see K, and it'll say like, this is where the exemption is. So all those page numbers you can refer and help you to kind of cover this. The next one deals with single family homes and condos, okay? And again, that's the code section, and it's found on page 9 through 10 of the law if you have it in front of you. So what that means, a single family home or condo, which means there's no other dwelling unit on the property except for a house or a condo. So this doesn't include where you have a house and an ADU, additional dwelling unit or a duplex. It's just a house, there's no other structure, or just a condo, and there's nothing else on the property. You're exempt, so let's say you own a house, you're exempt if the owner is not a real estate investment trust, a REIT, okay? That if the owner is not a corporation, and if the property is owned by an LLC, you can't have any member that's a corporation, okay? So what this basically means is if you own a house, let's say in your name or the name of your trust, just a regular trust, not a REIT, and basically you're not incorporated, then basically your property is exempt. So single family homes and condos where it's in your name or name of your trust, the property is going to be exempt. Okay? The other thing, in order to make this exemption stick, if it's a single family home, you have to give the tenant a notice that you're exempt. If you don't give the tenant a notice that you're exempt, even though you might be exempt, right, because it's a single family home, you're not exempt. So you have to have everything in one and everything in two serve the notice, okay? And that's when you'll have the exemption, okay? So the example is a single family home, condo or townhome, where landlord does not live in and has provided notice of exemption. So if you own a couple of houses, hey, I want to make sure I fall into number one, that's right. I need to make sure I give notice to the tenants that I'm exempt. So there's certain notices under the new law. There's actually two notices. Well, there's potentially multiple notices, but there's two notices. One is I'm exempt from the law, and the other one is the law applies to me, okay? And you're gonna have to give one of those notices to each and every tenant of yours if the law applies or doesn't apply. This is a sample of the language that needs to be on the notice. Now you notice I put this code section as well as where I got the language from, page 9 and 10 of the new law. And this is the actual wording that you need to give your tenants, okay? Now note on the very bottom, this has to be served, this notice has to be served, okay, by January 1st, 2024, okay? And any tenancy that happens after January 1st, 2024, it has to be stated in the lease, okay? So all your tenants right now, you need to serve this notice to them, basically stating that you're exempt before January 1st. All new leases after January 1st need to be, this notice needs to be, this verbiage needs to be in your leases. Does that make sense? I'm sure AOA is probably, everybody in the state, not everybody in the state, I'm sorry, everybody in the city of San Diego is probably going to rewrite their leases or maybe have some type of addendum so you guys can either add it to your current lease or when you execute a new lease, it already has the language in there so you don't have to worry about it. So this is the notice telling the tenant that I'm exempt from the law, okay? Now let's say you're not exempt. Hey, I have a duplex, I don't live in a duplex, the law applies, right? This is the notice that you need to serve on your tenants, okay? So all tenants that the law applies for, you need to serve this notice. Now the time period for this is a lot shorter. You have 90 days from June 24th, 2023 to give them a copy of that notice. In addition to a copy of that notice, you need to give them also a copy of the Tenant Protection Guide. It's about a 20-page booklet. There's the link. So if you guys downloaded, if you scan the QR code and you have it, you touch on the link, it will take you to the Tenant Protection Guide. So, and you would have to hand that to every single tenant, right, that the law applies for. Here's your notice, right? And here's a copy of the Tenant Protection Guide. Does that make sense? Real quick. Yeah.
So if 2 or 3 people live in the house, each one has to have a copy?
Good question. 2 or 3 people live in the house, so each one need to have a copy. Typically, when you have one or more tenant and you have, let's say you have 2 tenants in a tenancy, as you know, when you're serving like a notice, you typically, if you serve one tenant, it's considered served on all tenants. So what I would do is I would address the notice to tenant 1, 2, and 3. Here's your disclosure, here's your notice, and here's a copy of the guide. That's how I would handle it, okay? Now somebody asked, actually I think it was Victoria, can I email it to the tenant, the Tenant Protection Guide, because it is a 20-page, 25-page document. There's nothing in the ordinance that allows you to email it to them. So, you know, I don't want to tell you something that might not later on be correct. So I would prefer that you actually have a physical copy of the notice and of the Tenant Protection Guide, and you serve them both together. Victoria?
So the copy I saw was 222.
It's not 222 pages.
It had a lot of like things to refer to. The first 15 were meetings, but it went through 100 and then it had like a gap and went to 222. But that's what I'm afraid of.
The Tenant Protection Guide just came out literally like maybe 3, 4, 5 days ago. So I'm not sure what you were looking at.
It was on the city site, but maybe they left it.
Right, so it literally came out 3-4 days ago. So if you go to this link, you'll see, well, you can see, right? It says San Diego HC.org Content Tenant Protection Guide. That's the PDF for the guide. So print that out with the notice. You need to serve it within 90 days of June 24th, so June, July, August, September 24th, to all the tenants that the law applies to. I'm going to have everybody hang on to questions, and I'll take the questions at the end, or else we're never going to get through this. Okay, so everybody understand that? So you have basically about another 60 days to get this done. Now, under the new law, like the old law, you can kick out tenants if they do something wrong. It's called at fault. They're at fault. They're either breached the lease or doing something else that's wrong. For example, they're committing waste, they fail to pay rent, they're violating some type of material term of the lease, they're causing a nuisance, noise, whatever. Illegal use, they're using the place to sell drugs, prostitution, whatever it is. They refuse to provide access to the premises. You post a 24-hour notice, you're trying to make repairs, and they're not letting you in. Or they assign the rental agreement or sublet to someone else. So this is all stuff that the tenant is doing that they shouldn't be doing. That's called at fault. Okay? Now we're going to go over the reasons. Well, if it's at fault, how do I kick them out? How do I terminate the tenancy under the new law if the tenant does something bad? Okay? So these are the causes: default in payment of rent, breach of a material term. Now, breach of material term, what does that mean? Hey, you're not allowed to have a dog. Or hey, supposed to pay your utilities. You're supposed to have renter's insurance. So any type of breach that deals with the breach of the rental agreement that doesn't include failure to pay rent, you have to serve a 3-day notice to perform, covenant, or quit. Then if they fail to perform within the 3 days, then you have to serve a new 3-day notice to quit. So 2 3-day notices to quit. Hey, get rid of your dog. You're not allowed to have a dog. Here's your 3-day notice to quit. On the 4th day, you go out there, the dog is still there. Tenant, here's your 3-day notice to quit. You're out of here, you breach your lease. So 2 3-day notices. Nuisance, you can do an at fault for nuisance. You're loud, whatever it is. Waste, refuse to execute a written extension of the lease. Hey, it's a 1-year lease. You want to renew the 1-year lease. I need you to sign something or whatever. The tenant refuses. As long as this renewal on similar terms, whatever that means, if you're just changing the rent, I think you're going to be okay. But if you have a lease that's 1 page long and all of a sudden you want the tenant to sign a 30-page long, it's probably not a similar lease, right? But if they refuse to execute the written extension, then that could be a reason to kick them out. Criminal activity by the tenant on the property or common area, drugs, beating up people, whatever you want to call, that could be considered at fault as well. Number 7, criminal threat to landlord or to tenant or tenants. In the past, in order to kick out somebody, the criminal conduct had to be on the property. So let's say your tenant got arrested, armed robbery. It didn't occur on the property. I couldn't use that as a basis to kick somebody out, believe it or not. But this now under new law, if they've done something criminally, armed robbery somewhere else, we can use it as a basis to kick people out, okay? So if they threaten, a lot of times tenants threaten landlords, other tenants, now we can do it. So if you're walking down the street or the grocery store or the tenant somewhere else and they start saying, I'm gonna kill you, I'm gonna do whatever it is, we can use that as a basis. Assigning or subletting the premises, refusal to allow the owner to enter, using the premises for unlawful purpose. Let's say you have a property manager, number 11. You have a property manager, you want them to leave and they haven't left. We can use that as a basis. Under the old law, they didn't have something for that, so it caused a lot of problems. And number 12, the tenant failed to vacate after they gave you notice. So a tenant gives you a 30-day notice, I'm leaving in 30 days, 30 days comes up, they don't leave. You can kick them out based on their notice to you. Just little quick things about when a tenant gives you notice. You need to confirm that you're accepting the notice. A lot of landlords don't realize this. So tenant gives you notice. You can't just sit there silent, because if you do, at any time they can withdraw the notice and they don't need your permission. But if they give you a 30-day notice, let's say they email you a notice, hey, I'm leaving, great, I accept your notice, okay? As soon as you say great, I accept, you don't have to say great, but hey, I accept your notice, right? The tenant can't unilaterally withdraw it. Does that make sense? So you've said, I accept your notice. On the 30th day, never mind, landlord, I'm not moving out. No, that doesn't work. You can hold them to the notice because you accept it. In order for the notice to be withdrawn, both the tenant and the landlord have to agree to withdraw the notice if you have accepted it. If you just get the notice, don't say anything, and then 2 weeks later the tenant says, I'm moving out, they can do that because you never told them that you have accepted their notice. Okay, so just be aware of that. Okay, there's continuing at fault. So with the at fault, depending on what type of property it is, if it's a Section 8 or it doesn't have Section 8, or if there's a certain deed restriction, it's either going to be a 3-day, 30-day, 60-day, or 90-day. Okay, but one of those, the cause has to be on the notice. I'm kicking you out because you have a dog. Okay, now here's something new. I don't know why they do this. It's just very complicated. The city of San Diego is setting up a commission. So whenever you serve a notice, you need to also give that notice to this commission that hasn't been set up yet. Okay? So the way the law reads is, look, once they set up this commission, quote unquote, this portal where you can submit these notices to the city, you have 30 days. After 30 days they get it set up, then you're required to notify the commission, right? So the commission is not set up right now. So what does that mean? If I want to give a notice for cause, get rid of your dog, you can. You don't have to give it to commission yet because it hasn't been set up. But let's say next month they set up the commission. Once you give the notice, we also have to serve the commission. Submit the notice through this portal. I don't know what it looks like because I haven't seen it yet. But yes, they've set up this whole new bureaucracy to receive notices. What if I don't give it to the commission? Well, then your notice isn't valid anymore, and I won't be able to base an unlawful detainer on that notice. Okay. Also, we talked about a breach of material term of the lease. You got to do 2 notices: a 3-day to perform and a 3-day to quit. Okay, just kind of lays it out a little bit more. For material breach of the lease, basically if it's something curable meaning the tenant can do something to rectify the situation. You're not supposed to have a dog. They can cure it by getting rid of the dog. That's why you have to give them the ability to cure it prior to the 3-day notice to quit, where you're basically saying you're in breach, the lease is over, I want you out. Fair enough? Okay, so all the things we talked about so far is the tenant did something wrong, right? And you want to get him out. Now we're going to talk about the tenant didn't do anything wrong, but the landlord wants the place back for multiple reasons, okay? Now these are the only reasons in the city of San Diego that you can kick out a tenant, right, when the tenant hasn't done anything wrong. Now just to be clear, all these things that we're talking about just deal specifically with the city of San Diego. Doesn't deal with the city of Del Mar, doesn't deal with the city of El Cajon, Coronado, National City. Chula Vista has its own crazy rules. So this is just city of San Diego. So the first question is my unit in the city of San Diego, right? If it's not, this law does not apply to you guys, okay? So assuming you're in the city of San Diego and you want to remove the tenant, you're basically dealing with the owner wants to occupy, you want to withdraw the unit from the market, you're subject to a court order or government order, or you want to demolish or substantially remodel the place. So let's talk about these, each one individually. Okay, so let's say you want to occupy the premises. What does that mean? Well, it only applies to the owner, landlord, the spouse, a domestic partner, children, grandchildren, parents, and grandparents. Aunts, uncles, you're out in the cold. Nieces, nephews, doesn't apply. It has to be one of those relations, right? If it's not one of those relations, you can't serve a notice. Does that make sense? Now, in order to be able to do this, right, you have to, for leases that were entered into prior to June 24th, you have to include that clause in your lease. So for all your current leases, you need to send something to the tenant basically saying, I'm amending your rental agreement with a clause that basically says, if I want to move in as a landlord, spouse, domestic partner, children, etc., I'm able to do that. If you don't have that clause in your current lease, you're not going to be able to kick out a tenant based on this reason. For tenancies that happen after June 24th, the term has to be in the lease. Okay? Does that make sense? So in order to get the benefit of this, it has to be part of the lease. If it's not in there right now, you have to add it in new leases, add it as a term. This doesn't include moving in a property manager. Okay? So a landlord, sometimes you have, let's say, larger properties. If it's larger than 16 units, in the state of California, you're required to have an on-site property manager. Sometimes landlords, in the past, you would just give a notice to somebody and move them in. But you can't use this exception, this exception to basically get a property manager on site. Only a landlord, owner, kids, grandparents, etc. Okay. The next one, number 2, on page 1314 of the law, right? There's the code section. Basically, you want to withdraw the residential property from the rental market. What does that mean? You want to sell. I'm selling the house. I'm selling the condo. I'm selling whatever it is. You give the tenants notice. Okay. Now, if you're not, okay, let's go on. Number 3, you're complying with the government agency or court order. I'm sure some of you guys have probably received a nasty little letter from the city of San Diego. Basically, you're in violation and notice to vacate. Or if you're part of a lawsuit and the court orders that the tenants move out because of habitability issues, structural issues, whatever it is, then basically we can use that as a reason to kick out, to remove the tenant. In the old law, they didn't have this exception, and it made it very difficult for us when the city's telling you you need to remove somebody. And it's like, well, under the tenant's right to know ordinance, the old no ordinance, they didn't have an exception for that. So it was very tough for us to do that. But now they cleaned up that problem where if you get this notice and order, I can use that as a basis to remove a tenant. Okay, and basically the order has to be related to habitability. That basically requires that the place be empty for at least over 30 days. It's to vacate residential property, not commercial. And if there's a local ordinance that's forcing you to remove somebody, then you can use that as well. Okay, here's a big one that a lot of people like to use. You want to remove a tenant because you're intending to demolish the unit, the house, or substantially remodel the residential property. This is going to be a little bit more stringent than what it was in the past. Okay, so here's what you need to do, and some of it is a little crazy. Prior to serving the notice, you have to get your permits. Okay, but so while you're getting your permits, after you apply for your permits, you have to post your application on the property. Now, this has already ran into some problems with some of my clients. It's like, well, some of these permits I get, I just hop online and the computer generates it and I pay my fee online. There's no real application, you just get it done. So I'm not sure how you can post an application when there really isn't an application. You just go on there, get it done, and it spits out your permit. So what I've been doing is just telling my clients, well, let's just post the permit, and hopefully the judge will understand there's no real application. Now, other types of permits, you actually apply to the city. I want to apply for X, Y, and Z, and you actually have an application. Fine, we can post that. But other things, if it's something minor that you can do on the computer and it just automatically generates it, I don't know if we need to take a screenshot of the computer. I don't know, but this is a little vague. I'm not sure what it is. But you have to do it within three days of the submittal of the application. Okay? Well, what if you don't do it? You might not be able to use this as a reason to remove them. Or maybe just reapply for the permit and go from there. You have to have the permit secured before we give the notice. Okay? So you got to post the application, whatever that means. You got to get the actual permits. I have all the permits for the work I'm going to do. Hey, I'm swapping out the water heaters. I'm changing the electrical panel. I'm putting on a new roof, whatever it is. You have to have all those permits pulled already before you can serve the notice. Okay? Now here's some other crazy stuff. The third one, part of this notice, so hey, you posted the application, you secured the permit, now we're going to serve a 60-day notice to the tenant. That 60-day notice is going to basically say, it's going to include a declaration from somebody, the owner or the authorized agent, under the penalty of perjury, stating the reason for the determination. I want to demolish, I want to substantially remodel, the type and scope of work to be performed. What I'm doing right now is getting something from the contractor. I am replacing the sewer line, changing the electrical panels, blah, 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 stating everything. Also the statement from the contractor or whoever, basically saying that the work can't reasonably be completed within 30 days, right? And that the work requires that the tenant needs to vacate for at least 30 days. Now, if the contractor tells you, well, hey, I can get this done in 2 weeks, you can't use this as a reason to kick out your tenant. what you would have to do is put your tenant up at a hotel for 2 weeks, make the repairs, and then move back in. But if the work is more than 30 days, then you're able to use this exception. But you're going to have to do a declaration stating all this stuff under the penalty of perjury. I certified under stated laws of California that the foregoing is true and correct, that I'm remodeling your unit, this is the scope of work, and can't be done with less than 30 days. What does substantial remodel mean? Here's where it gets a little bit more stringent. In the past, some landlords were able to basically get by with, well, I want to substantially remodel the unit. I'm putting in new kitchen cabinets, new this, whatever. When you do that type of work, you really don't need a permit. So they can say, well, I didn't really need to pull any permit to substantially remodel the unit because you're not required to pull permits if you're putting in, let's say, a new kitchen, right? Cabinets you don't need, and other work like that. Now, substantial remodel means the replacement, substantial modification of any structural, electrical, plumbing, mechanical system that requires a permit. Okay? So you got to do work that requires a permit. Okay? Or certain things that don't require a permit is you're trying to abate certain hazardous material. Lead paint, mold, and asbestos. If you're trying to remove lead paint, mold, and asbestos, you don't need a permit. Okay? So in those things you don't need a permit. But let's say you don't have any lead paint, mold, and asbestos. The work you need to do to substantially remodel has to be work that requires a permit. Okay, does everybody understand that? And also, the requirement that it takes more than 30 days. So typically, I usually tell my client, talk to the contractor, because if we end up litigating this, I'm going to need somebody to testify, hey, replacing the sewer line, doing this X, Y, and Z is going to take more than 30 days. Okay? If the contractor doesn't feel comfortable saying that, then we're not going to be able to move forward, right? The contractor says, oh, well, I can swap out electrical panels in a week. Okay, well, we can't use this. Substantial remodel does not mean cosmetic improvements, painting, decorating, minor repairs, and other work that can be performed safely without having the person vacate. Hey, I want to paint, I want to put new carpeting, new flooring, I want to do X, Y, and Z. That's not going to work. Okay, so we're still in no fault, okay? So no fault, what is the type of notice you need to give? Depending on what type of property it is, it's either going to be a 30, 60, or 90 days. Typically, for most properties, it's going to be a 60-day notice. On that 60-day notice, it has to state the cause. So what we typically do is state word by word exactly what the law says. Hey, we're going to substantially remodel or demolish the place. Hey, I'm going to move into the premises. And then you're going to, remember, day one, if your property applies, if this law applies to your property from day one, and let's say the next day you want to do something, remove them at no fault of the tenant, you're going to have to pay up to 2 months relocation benefits. And if they're a senior or disabled, and I'm not sure what disabled means yet, I believe it's going to refer to the federal definition, but it's unclear in the ordinance, right? It may be 3 months. So if you're a senior or disabled, you're entitled to 3 months relocation benefits. If you're not a senior and you're not disabled, it's going to be 2 months. And the other new thing that they added, if you remove a tenant at no fault of their own, and the tenant comes to you and tells you certain information, basically telling you, look, I'm a tenant here. I want the ability to re-rent the place within the next 5 years, then they have a right to re-rent the place if you place that unit back on the market. Okay, let's use an example. Let's say one of the excuses is, I want to move in, I'm a landlord. Okay, great. The tenant serves you a notice basically saying, look, I want to be able to come back in the next 5 years if you move out. 2 years later, 3 years later, 4 years later, you decide I'm going to move out, right? You would have to contact the tenant and say, hey, I'm moving out. You told me you want the possibility of coming back in. The rent currently is X. Do you want to come back in? You need to hang on to these things from your tenant for 5 years, right? And reach out to them if you move out. Let's say you substantially remodeled. Let's say, and it took you 3 months to do it, and they serve you the notice saying, hey, I want to try to move back in. Now, the rent could be market rent. Okay, but you would have to keep the tenant's notice that they want to try to come back in, and then reach out to the tenant once you're done and say, hey, it's remodeled now. Do you want to come back in? The rent's going to be X. And there's a whole procedure of how to handle that. But I just want to throw that out there.
Is it the tenant's responsibility to sort of keep in touch with you, or do you have to keep in touch with them?
The question is it the tenant's responsibility for them to keep in touch with you? All the tenant needs to do is serve you notice. So you served the tenant a 60-day notice, you need to move out for X reason, right? They can turn around and say, here's my notice, here's my telephone number, address. There are certain things they have to tell you. If it becomes available again in the next 5 years, you need to call me. So after they give you the notice, it's your responsibility within that 5 years to reach out to the tenant at the address, the telephone number that they gave you. So you're required to hang on to those things for 5 years, okay? And you also have to give the notice to the commission within 3 days of when you serve this notice. So here's a 60-day notice. I served it on the tenant. Now I need to serve it on the commission too, through this portal that hasn't been set up yet. Okay. Okay, so next thing we're going to talk about, the new law covers buyout agreements. They call them buyout agreements. Most people call them cash for keys agreements. So what can you do with the cash for keys? Prior to making any offers to the tenant, okay, you have to give the tenant a written disclosure, okay? And that disclosure has to be given to the tenant, okay? And then they need to sign that disclosure. And then you need to hang on to that disclosure for 5 years. This is fun stuff. So here's a sample of what that disclosure looks like, okay? It basically tells the tenant what's on there, but it also tells the tenant who can negotiate on behalf of the landlord. Hey, you can talk to me, I'm the owner, Mr. Smith, or my property manager, Joe Taylor, and we're the ones that can negotiate with you. So before you even talk to your tenant about a cash for keys agreement, you have to give them the disclosure, they have to sign it, and you have to sign it, and you got to hang on to that, okay? Now, the buyout agreement, the actual buyout agreement, cash for keys agreement, what are the requirements for that? It's got to be in writing, okay? A copy of it has to be given to the tenant when the tenant signs it, okay? So let's say you go to the tenant's unit. Hey, here's the agreement we agreed upon. Have 2 copies. Sign both copies, tenant. Here's your copy, here's my copy, okay? Also, there has to have a statement of the tenant's rights. There's certain rights that got to be in that agreement next to the signature block of that agreement, okay? Now, sometimes landlords sometimes landlords negotiate rental contracts with the tenants in a different language. Let's say Spanish. Let's say you speak Spanish, you negotiated the contract with somebody in Spanish, then the buyout agreement / cash for keys agreement needs to be in Spanish as well. If you don't have all 4 of these things, the agreement is void. If it's not in writing, it's void. If you didn't give a copy to the tenant when he signed it, it's void. If you don't have that statement next to the signature block, it's void. If you didn't translate it in the right language, it's void. Other reasons why it might be considered void. So besides the 1 through 4 that we just talked about, okay, the relocation benefits pursuant to the buyout agreement can't be less than what they're allowed under law. So let's say you serve a 60-day notice, no fault of the tenant, they're entitled to 2 months. That buyout agreement has to give the tenants at least 2 months benefits. Does that make sense? Let's say you come to some agreements, well, it's only 1 month. The agreement's going to be void. Or I'm only going to give him $1,000. Agreement's going to be void. So it's got to be at least what's provided by this law. Okay. The other thing, a tenant can't waive their protections under this act for buyout agreements. So you can't include something in agreement saying, well, I'm the tenant and I agree, I don't really care about this law and I'm willing to accept $1,000 instead of the 2 months. It's going to be considered void.
And you're saying 2 months rent, correct?
2 months rent, actual rent, or 3 months if you're senior or disabled.
Only in the city of San Diego.
This is just the city of San Diego.
What do you do outside San Diego?
What do you do outside? Each city, here's a nightmare. Each city, some cities have not passed their own laws. So let's say you're in El Cajon. El Cajon hasn't passed their own laws. If the city hasn't passed their own laws, then you're fall under AB 1482, which means you fall under the state law. And the state law is similar to San Diego's law, but it's different. If the city does have a separate law, like San Diego does, or Chula Vista, then you got to follow the San Diego law or Chula Vista law and not the state law. Does that make sense? So if you call to my office, we run through a bunch of questions like, what type of property is it? Single family, multifamily, duplex, ADU. What type of financing is it on it? Because it's the federal subsidized financing. Different rules apply, federal laws apply. What city is it in? Because what I'm going to tell you is, if it's in San Diego, it's going to be different when I tell you it's El Cajon, when I tell you it's in Chula Vista. So it makes it hard if you're a landlord and you own property across the county. Different laws are going to apply on different properties depending on where they're located. Okay. Say it again. What about, there's certain parts of the county are unincorporated. That would typically fall under state law because the unincorporated area probably does not have their own ordinance. Does that make sense? So right now in San Diego County, I believe the only two cities are Chula Vista and San Diego that have their own law.
I understood, because I've been listening here, and I understood that in order to buy them out, they have, maybe I misunderstood, that you have to give them, say that they're due a 60-day
Notice.
notice, and they have to get their 2 months rent-free. But in order for us to buy them out, I understood that we have to give them more than that. Is that correct or not?
No. So the question is, under the new law, do you have to give, if you want to do a buyout agreement, do you have to give them more than what they're legally entitled to under law? No, you have to give them at least what they're entitled to under the law.
Thank you.
Okay? So if they're entitled to 2 months, the agreement has to be at least 2 months or more, right? But it can't be less than 2 months. Okay? Now, in the buyer agreement, you have to have a certain statement in your cash for key agreement, buyer agreement, and that's the statement that's required in all cash for keys agreement. Okay? And it has to be next to the signatures, and it's got to be in 14-point font. So I think initially when you start with some of these cash for keys agreements or buyer agreements, it's probably a very good idea. You talk to an attorney, my office or somebody else's office, and say, hey, I want to try to do this. Let's go over what I need to do and kind of get 1 or 2 done by the attorney. And then maybe after that, if you feel comfortable and kind of know how it goes, then take a shot at it, do it yourself. But otherwise, we'll go over the penalties landlords could be subject to if they don't follow this law, and it's just not worth it. Okay? Let's keep going. Now, what if a landlord violates this ordinance? What can the tenant do? Okay? The tenant can seek injunctive relief, equitable relief, money damages, including punitive damages. Punitive damages is, landlord, you were very bad, so even though the tenant is out $7,000, we're going to throw in an extra $10,000 because we don't like you or we don't like the actions that you did, right? In a civil action against the landlord. So the tenant could sue you as a landlord under this ordinance in a separate action, okay? They can raise a violation of this ordinance as an affirmative defense in reference to an eviction. What does that mean? You file an eviction against the tenant, then the tenant comes back in their answer and basically says, look, the landlord's not entitled to possession because they violated the ordinance. And this is how they violated it. They forgot to give the notice to the commission. So the judge says, well, hey, you failed to give the notice to the commission within the 3 days. Your notice is defective, you lose. Okay? File a civil action for wrongful eviction and for damages not less than 3 times the actual economic damage. What does that mean? You did the ordinance, you try to follow the ordinance, you did an eviction. Afterwards, the tenant realizes, hey, you didn't do it right under the ordinance. They can sue you, okay, for a wrongful eviction. You kicked me out wrongfully, and it could be up to 3 times their actual economic damages. Hey, I had to move. It cost me $1,000 to move. Now my rent, instead of being $2,000 a month, is $2,500 a month. I was under a lease, so now I'm damaged an extra $500 a month, et cetera, up to 3 times. Okay. Next one, demand not less than 3 times the required relocation assistance and actual damages the landlord fails to provide the assistance. So you failed to provide the relocation assistance, and now they're coming back to sue you. This last one is not good. I don't like this. Recover attorney's fees and costs. Okay, this only applies when the tenant's suing you as a landlord. It doesn't apply when you're suing the tenant in an eviction. Okay? That's just not nice. I don't like attorney's fees clause. The reason why I don't like attorney's fees clause is it kind of drags in attorneys on the tenant's side. Okay? So I typically say if you're going to have an attorney's fees clause, cap it. Cap the attorney's fees and costs at $1,000, $1,500. Okay? Now this basically says if you violate this ordinance, the tenant sues you, they can and they win, they can recover their attorney's fees, even though your rental agreement with the tenant has a cap on attorney's fees or no attorney's fees clause at all. Does that make sense, everybody?
You drop your voice when you start to do that. Bring your voice back up.
Okay, I'm going to be louder. How about that? So, right now, let's say you have a rental agreement and it has no attorney's fees clause. The prevailing party in the litigation is not entitled to any attorney's fees, or they're entitled to $1,000. This law basically says if the tenant sues you because you violated this ordinance, they're entitled to their attorney's fees if they win. Say they sue you, you spend $20,000 litigating this, the tenant spends $10,000, $20,000 litigating this, and the tenant wins, you have to pay their attorney's fees. Does that make sense? Even though your contract with your tenant didn't allow for attorney's fees. Does that make sense? Okay, I think so. If not, we can ask questions. Okay, so is there any hope? There's one thing, and remember, this just came out. There hasn't been any cases that have ruled on what the language means. I haven't started a case yet. The most I've done is issued notices based on this. So I don't know how the court's going to read this. But in the statute, in this ordinance, it basically says the ordinance does not apply to tenancies. Okay, basically. It doesn't apply to tenancies less than 30 days. And I thought, okay, well that kind of makes sense. Let's say you're doing an Airbnb for a week or two, it doesn't apply. Okay. But the next part says, the law does not apply to a tenancy where it's a lease of 3 months or less. So if you have a tenancy that's 3 months or less, right, it's not considered a tenancy under the law. The way I read it is, if you did a lease for 3 months and it's renewable every 3 months, it's not considered a tenancy and the law doesn't apply to it. So the way I read it is, what's stopping landlords from basically any new tenant that comes in doing a lease for 2 or 3 months that's renewable every 2 or 3 months, because then you can point to it and say, this is not a tenancy that's subject to this law. It's not an exemption. You just don't fall within the definition of what a tenancy is. Now, these two things are a little weird and they don't make sense, right? Because one says, well, if 30 days or less is not part of it, but more, it might be. But then the next paragraph says, well, a tenancy doesn't include a lease for a fixed terms of 3 months or less, or any sanctions or renewal of this. So it's a little wonky. So I don't know if the legislature or the city council realized this is a big hole. You can drive a truck through this hole. So what I'm recommending to landlords is like, from now on, every tenancy, make it a 2 or 3 month fixed term tenancy. Hey, your tenancy is from January 1st, 2024, whatever it is, to March 1st, right? Or end of February. It's a 2-month tenancy that can be renewed every 2 months. And you need to have notice 30 days beforehand, written notice, or 15-day notice, whatever you want to put, or it could automatically renew, right? And then you can point to it, and I can point to it and say, well, Your Honor, this law doesn't apply because a tenancy doesn't include anything that's a fixed term less than 3 months.
So how does a month-to-month fit into this?
Question is, how does a month-to-month fit into this? Well, it says tenancies less, it's got to be, if the tenant has a right to be there for more than 30 days, okay? The problem is some months have 28 days, 30 days, 21 days. I don't know what to do with that. So if you have a month-to-month agreement and the tenant's there during a month where there's 31 days, well, it's more than 30 days, right? But then we have also the second part that says lease of 3 months or less. Well, it's 3 months or less, so I should be able to do a month-to-month to exclude it. Now, these two conflict, right? I think the best way to do it is so it's nice and clean and that we can point to something and say, your lease is for 2 months, your lease is for 3 months. then we don't have to worry about the weird language between the two. I can just point to the second thing and say, well, Your Honor, this is a tenancy for 3 months, right? Or less. Hey, I'm going to do 2 months, right? 2-month tenancy. It's renewable every 2 months. It falls outside this law. Remember, it's not an exemption. The exemption notice that you serve on the tenant says, I'm exempt because of X, Y, and Z. It's a single family house. I'm not a REIT. I'm not a corporation, blah, blah, blah. Well, that means you're exempt, but this is basically saying, I'm not even part of this because what I gave to the tenant is not a tenancy as it's defined, right, on page 7 of the law.
So if you're on month to month, can you bill your tenants out if they voluntarily sign a 3-month lease with them and start 3-month leases?
Well, he says, well, what if you're on the month-to-month currently, right? Can you kind of have them sign something new? I don't know the answer. I think the answer is probably no, right? Because when you started the tenancy, well, again, you're going to have the problem. I don't know how they're going to read the first portion of this, how the judge is going to read it, because, hey, we have a month-to-month. Well, it is a tenancy. Well, it's a month-to-month, but certain months are more than 30 days. So it doesn't fall into the first one, right? They can argue it doesn't fall in because there's 31 days. Well, then, but you can say, well, then it's still less. It's for a fixed term of 3 months or less. And you can say, well, it's not technically a fixed term because it's a month-to-month. I will argue, well, it's a fixed term for 30 days, right? But it might not say that in your rental agreements. Typically, it will just say it's month-to-month agreement. It doesn't say it's a fixed term for 30 days, right? So I don't think it's going to work, but definitely, and we could try it, but definitely for new tenancies, do a 2-month or 3-month tenancy. And then one day we'll fight this and see if it works.
So, I mean, in our case, we've got leases that have expired that automatically revert to month to month.
What if you have a lease, let's say you have a 1-year lease and it expired. Well, the lease was greater than 3 months, so that definitely will not work, right? If you have a 1-year lease on a tenant,
That lease is no longer in effect, it's expired. So could we now go back and say we'll do a 3-month lease?
so what if you sign a 1-year lease 3 years ago, but now converted to month to month? Can you use this exception? It's not even an exception. Can you use this definition to get around it? Probably not, because when you signed it, when you signed the agreement, it was more than 3 months. So the other side could argue this was a 1-year lease. It doesn't fall into the first definition, right? And it doesn't fall in the second one because it's not less than 3 months. So I don't think it will work in that situation.
Can we renew after the 1-year lease expired?
After the 1-year lease expires, yes, but you're going to be...
Under these terms?
No, because like I said, your first term was greater than 3 months. So it's considered a tenancy. When you entered into the agreement on a 1-year lease, it was greater than 3 months. It's a tenancy within this definition. So
Now we apply to the new tenants.
I would say new tenants do 2 or 3 months.
How does this affect the day 1 protection?
That's what I was.
Say it again.
How does this affect the day 1 protection?
How does this affect the day 1 protection? Your argument would be, and my argument to judges, it doesn't apply. The tenancy isn't the tenancy that's subject to this law, right? So there is no day 1. Well, you can say it applies day 1. The law applies, but according to the law, it doesn't apply to that particular tenancy. Does that make sense? So it's kind of like an exemption, but the exemptions are laid out. But this is in the definitions. We are defining tenancy to mean, and that's the actual language that's from the law. It means this. So the argument is, Your Honor, I have a 3-month lease. I have a 2-month lease that's renewable every 2 months. That's not a tenancy. Only tenancies that are greater than 3 months apply, right? And so it doesn't apply to me. None of this applies.
Sir, if you do 3-month renewable leases, is there a cap on how many times you can keep renewing that?
There's no cap. That's the language. That's the exact language, including any extensions or renewals of that lease for fixed terms of 3 months or less. So any extension, any renewal of the 2 or 3 month lease works. You can have 10 of them, 1,000 of them.
One of the council people's office told me they're only going to allow it 1 time to renew those 3 months if you do that.
That's not what it says. So I think this hasn't blown up yet. So, and I mean, it's pretty, well, it's horrible writing, right? But it's pretty clear it doesn't include fixed terms leases of less than three months or less. So if I show this to a judge, it's like, look, it's clear. There's no limitation on it. It doesn't apply to our tenancy. So at a
30
minimum,
days, or they have a different definition?
say it again?
What is the city's definition of a month? Is it 30 days or like a fourth to the fourth?
Well, okay, the question is, what's the city's definition of a month? It depends. You know, we have an issue a lot of times in non-lawful detainers is like, well, let's say the rent's owed for February, and February is 28 days. When you're calculating daily value of February, do you use 28 days or 30 days? I typically advise clients to do 30 days because it's less, right? The per daily value is less. So let's say the notice expired February 15th. If you calculate the rent on a 30-day thing, then each day's rent is a little bit less than if you calculate it on 28 days. You always want to be less on your 3-day notices. If you're less, you're okay. But if you're 1 penny over on the rent, you lose. So as a back fault, you have some judges that might say, well, no, I think it should be 30 days, and you put 28 days, you're going to lose because you're a couple cents over what's owed. So what's my response? I don't know. The court's not clear on what specifically a month means, okay? And I can double check, but I don't believe they define what a month is in this new law. So what am I telling you guys? And the minimum moving forward with the new law, do 2 or 3 months, okay? Fixed term. Your term of your lease is 3 months. Just spell it out, write it out, whatever you need to do, and it's renewable every 3 months. If you want to put something like, so it doesn't automatically renew, you can say it only renews if both parties agree in writing 30 days ahead of time, 50 days ahead of time. Because if this law doesn't apply, right? Let's say the tenant's been there 12 months. It's renewed 4 times. 3 times 4 is 12 months. After that, it's like, you know what? I don't want this tenant anymore. He's causing problems, blah, blah, blah. I'm not going to renew it. The lease expires. Then if the tenant doesn't move out at the expiration of the lease, I can start an unlawful detainer based on the expiration of the lease, which doesn't require notice. What? What about all this stuff? Remember, the law doesn't apply, right? If this law doesn't apply, then you can kick out somebody at the expiration of a fixed term lease. None of this has been tested, but that's why I put the writing up there. I tell my staff, make sure they see the words. If you are a normal person, a judge reading this, how would you read, a tenancy doesn't include a lease for a fixed term of 3 months or less? It's pretty plain.
So if this law doesn't apply, then will AB 1482 kick in?
No. Okay, that's a great question. If this law doesn't apply, does the state law apply? No. It's all or nothing. Because the city passed this law, this is the law. And this is what you got to follow. It's not, well, if this doesn't apply, you go to the state law. No, there's only one law. It's either the state or the city passed its own ordinance. Here, the city passed its own ordinance. We don't care about the state law. We need to follow this. That's the only law out there for city San Diego. It doesn't apply to tenancies less than 3 months. Okay. Say it again.
Rent increases?
Rent increases?
Those are under the state.
Rent increases are under the state. That's correct.
For the
That,
city of San Diego.
yeah, that's different from this. Okay.
No, I mean, it would confuse them, that's why I don't.
Yeah. So rent increases fall under different laws, and you guys know it's right now.
When you do the extension, say a lease extension for 30 days or every 3 months, you have to go through and do all the paperwork, like where habitation stuff, like this is clean, this is clean, this is clean, all over again?
Every time you, so I think the question is,
Like you said, if you get a release every 2 to 3 months, you have to go through the property with them again and.
no, question is, let's say you have a lease and it renews every 3 months, or even if it renewed every year, let's say. In normal cases, do you have to go in and do a whole new checklist? No, you don't have to. Is it a good idea if the tenant's been there for a couple of years to kind of go inside and figure out what's going on? Yes. But no, you wouldn't have to do a new checklist every time. Okay? Say it again?
I did not know this is already unactive.
Yes, it became active June 24th, 2023.
Well, when the city council did their program, and the whole business was keep the homeless off the street. What has this done for the homeless off the street? I don't know, I'm more furious or frustrated.
The question was, hey, when the city council passed this, one of the reasons why they use for passing is they want to keep the homeless off the street, or maybe not increase homelessness. And so the question is, well, is this really helping people or stopping people from becoming homeless? I don't know. It's just passed. I think the net effect of what's going to happen with this law, it just makes it more difficult to get the properties back, right? It makes it more costly for a landlord. If things are more costly and more difficult for a landlord to do things, remodel units, then less likelihood that the landlord's going to remodel a unit, right? So what happens, the condition of the general stock of rental units is going to slowly over the years go down. And I'm sure you guys heard of New York. They've had rent control for 50, 60 years. And there's some units out there, the owners do absolutely nothing to them because their rent is $350 and it should be $6,000 a month, right? They're not going to do anything. So the tenant, they want something fixed, they do it themselves because they don't want to give up a unit that's paying $350. So generally, and it doesn't make sense for a landlord to go in there and spend $100,000 fixing up the unit because if the most they can get is $350 an hour, a month. So the general stock of rental units that are under rent control slowly go down. I suspect the same thing is going to happen in San Diego. Somebody who normally says, you know what, this house hasn't been remodeled in 30 years, it has an old kitchen, 1980 kitchen, I think I'm going to go in there and fix it up and spend some money. They might not do it because it's like, well, if I have to remove the tenant, I'm going to have to pay 2-3 months. If they don't move out, then I have to start an eviction. That eviction might be expensive. The courts are completely backlogged and screwed up right now. It's taking months to get certain things issued by the court. Like a writ of possession is taking 3 or 4 months to get issued. Where back in the day, 20 years ago, I used to walk the paperwork down to the clerk's office, sit there for 10 minutes, they would issue the writ, and I walk down to the sheriff's department and give it to them. Now it's taking 3 or 4 months, I'm not sure why. And then once I get the writ, I go to the sheriff's department, it's taking the sheriff's department 30 to 45 days to go out there. So once the trial's over, it's taking 4 to 5 months to effectuate what the judge ruled on. So all this is going to have an effect of reducing what the units look like, increasing the rents. If you're a landlord, what are you going to do? It's like, well, if I kick out somebody, now I have to pay 2 months relocation, right? I might have to do an eviction. That eviction might take 10 months. I'm going to be out a lot of money. When that unit becomes empty, I thought I was going to rent it at $2,000. No, I'm going to rent it for $2,400, right? To try to recoup some of the losses. This is my opinion based on the way I see things and my knowledge of the rental markets and economics. It's going to force rents up. So I know what the city council is trying to do. I think they are saying, well, I'm trying to protect the homeless, but I think what's going to happen is just going to drive up rents and then cause more homelessness, less units being built, lower the condition of the units that are there. That's just my personal opinion.
It's so nonsensical, you can't understand. That's, I don't know how we're supposed to.
Yeah, so in the past, I could see landlords doing their own evictions, their own notices. I'm sure you guys have done 1 million 3-day notice to pay rent or quit, 1 million 3-day notice to perform. But now all of a sudden, let's say a new notice for I want to substantially remodel a place. It took me and my partner sitting down, reading the law and trying to make sure everything's perfect. It took us a couple hours to work up that notice. And part of that is we have to add certain language in there. And we have to specify certain things. We have to work on the declaration. Got to make sure we have all the permits. We have a letter from the contractor. We got to make sure the tenant's guide's there. We got to make sure the application gets posted within 3 days. This is just a lot of work. And so unfortunately, it just forces landlords to retain counsel when in the past they could do it on their own. So, it's difficult for us, and I've been doing this for 30 years to try to figure out all this stuff. I just can't imagine a normal person, a non-attorney person, trying to figure this out. But this is important. I don't want to undercut what we did here today. You guys at least have an inkling of what's out there, and you know what? I know what the law is. I might not know exactly how to apply it, but I know I need to do certain things. So I'm going to reach out to people to help me. I want to do this type of notice. I need to do X, Y, and Z. How can I help doing it? So it's important you guys know generally what the law is about, so you don't just stumble through and start giving out notices and doing things, entering in a cash for keys agreement, because now you know, okay, before a cash for key agreement, there's certain things I need to do. So let me talk to somebody. Let me reach out. Hey, attorney, what do I need to do? Hey, first thing we got to do, give them a disclosure about their rights about cash for keys agreement before we start talking to them. Great. What is that notice? Here's a copy of it. Let's get them signed. Okay, that's done. Now I can start talking to them. Great. Figure out what the terms are. Once you get the terms, come back to me, and I'll make sure the agreement falls within the requirements of the new law, and then we can go from there. We have their hands up?
Yes, I know that all of us have to give our tenants notice of this new protection. Does the city of San Diego have a hard copy of this notice since it's 18 pages long? Is there like a hard copy, like a brochure?
Okay, the question is,
booklet?
I think you're confusing the notice with the tenant protection guides. Yeah, so it's not a notice, it's a tenant protection guide. In one of my slides, it had the link. You click on that link, it'll take you to the PDF. I believe it's 18, 20 pages long. You need to download it, print it out, and give one to each tenant.
12-point font.
No. The book is already the book, right? The guide's already the guide. You're just providing a copy of that with the disclosure that, hey, this law applies to your tenancy.
But the city of San Diego doesn't have something that's already pre-printed that we could just get copies of it?
So the question is, does the city provide copies of all these things? The city's not going to provide copies. No, the guide, the city's not going to, here's 100 copies of the guide. I'm not aware that exists. I don't think the city will do that. It's just a cost they don't want to bear. They did provide it in PDF form I believe, with the understanding that landlords will just print it out.
What about cash for keys on an eviction for non-payment rent?
Okay, good question. What about a cash for keys agreement in an eviction? It wouldn't be called a cash for key agreement. It would be called a stipulated judgment. Okay, a stipulated judgment is an agreement between the plaintiff and the defendant in an eviction of how the case is going to get resolved. That's different from a cash for keys agreement. Okay, so we would just follow the way we typically handle those stipulations if you ever had an eviction. So it wouldn't be a cash for key.
Does the gap has to be in big format or can it be in?
I didn't hear you. I'm sorry. Say it again.
Can the guide be in paperless?
Can the guide be paperless? So the question, I think Victoria said, can we email it to the tenant? I don't see anything in the law saying you can. So I would recommend not doing it. Because if you don't do it, then maybe you didn't follow the law, and then you thought you were exempt. Now you're not exempt. So I would give a hard copy.
So can we mail it, or do you have to post it, or anything in person? Does it matter what form?
Can we mail the notice? You can mail the notice, and including the guide. Okay. You can also personally serve it. So you can go the one there. Let's say you have a 10-unit building. Just have the disclosure, the appropriate disclosure, plus the tenant guide, and just kind of hand it to everybody. Sometimes, it came up, does the tenant need to sign for the disclosure? They don't need to sign for the notice. If you want them to sign it so later on they can't say I never got it, fair enough. But you're not required to. Does that make sense? Now remember, there's different timelines, right? One timeline is you got to do it within 90 days of June 24th. And the other one is you got to do it by January 1st, 2024. Okay?
Why do we have to, why couldn't we text, email it to them, like we do the lead-based cable for the environmental?
Why can't we just email it to the tenant? Because it doesn't say in the law that you can. So I'm always on the side of doing things conservatively, right? Because you don't want to be in a position where, hey, I emailed it to them with the disclosure, and then I've started trying to start an eviction, unlawful detainer. Then the defendant's attorney says, well, no, that wasn't properly given to the other side. There's nothing in the ordinance allowing a landlord to email the documents. And then I have to scramble and show the judge where in the ordinance does it allow a landlord to email, and I won't be able to find it, as opposed to, you know what, Your Honor, I mailed it or I handed it to them to Does it say mail specifically? No, it does not say mail. Well, the difference is email is special. In different parts of the statute dealing with other cases and other things, there are specific statutes that say, hey, you can email or fax this document to the other side. So the way I look at it is, in other cases and other situations, there's a specific statute that allows a person to do something via email or fax. So the argument on the other side is, well, Your Honor, if the city council wanted people to allow them to email it, they would have done what they've done in other situations and have a specific law saying it's okay to do it that way. In this situation, they didn't do that. So you see how the argument is? So again, I'm trying to be conservative. Would the judge say, you know what, that's fine? The judge could say that, right? But again, I'm trying to avoid problems. So
Can you send a letter, provide them a link that download their own tenant?
say that again, I didn't hear you.
With the link? And
Can you send, no. I mean, okay, so can we send an email that has the link? Now you're going to even,
a letter.
you send the letter with the link. The statute, the ordinance says you need to provide them a copy. It didn't say you need to provide them a link to get a copy, right? So no, see how it kind of rolls? Well, what if I just talk to them and say, hey, go on Google and look it up and download it? Is that going to be sufficient? No, we're getting further away from what needs to happen.
Our property management companies now, are they going to be responsible for this, sending this out, or?
The question is, if you have a property management company, are they going to be responsible for sending these things out? They should be. Hopefully they have some type of an attorney that they're on retainer with that helps provide them. But now you are probably more educated about this law than your property manager is. So I would reach out to your property management company and say, hey, when are you guys going to send out the notice of exemption or the notice that this law doesn't apply? And hey, when are you going to provide the tenant guidebook? And they say, well, like, what are you talking about? Here's a slideshow.
That needs to go out to all of your units.
All the units, if it applies. And I would mention to them, hey, property manager, from now on, don't execute any lease unless it's a 2 or 3 month lease.
How about Lemon Grove or La Mesa? I got properties there.
What?
Might not apply.
Okay, the question is, what about Lemon Grove and La Mesa? Remember, Lemon Grove is a separate city. La Mesa is a separate city. This applies to San Diego. Okay?
So what would I have to do? I don't have to do anything yet?
For Lemon Grove and La Mesa, they're different cities. They don't have their own ordinance. They fall under 1480, AB 1482, the state law.
Is that the old law now?
It's not the old law. That's the current state law. This law replaced the city of San Diego's prior ordinance. Okay? So we have the state law. This is a new city law.
Because we don't have to send notices out.
You don't have to send any new notice. You just need to follow the state law in El Cajon and La Mesa. We're going to do.
Keeping that envelope filled with the information to their door, and then they say we didn't get it.
Can I post it on the door? I'd probably say don't do that. So I would mail it or hand it to them. Remember, on some of these things, some of these notices, after January 1st, 2024, it's got to be part of your lease. So this notice, any new tenant, that's a good point. Yeah, let's say you have a new tenant coming in tomorrow. Give them a copy of the guide, right? Hey, here's a copy. Can you sign something saying you got the copy? And hey, here's your exemption notice or saying your tenancy applies. But if you're doing a 2 or 3 month tenancy, right, you might not need to do all that stuff. If you have a property manager, reach out to them and say, look, I want to do this moving forward. How do I find a complete law for county guide ordinance? Each city has different laws. In the county, unincorporated portions of the county, they don't have a separate law. So they follow the state law, AB 1482. How do I get the complete guide for the tenant laws in the unincorporated portions of the county? Okay, there's numerous statutes. There's hundreds.
You can't find them all together like you have here.
No, and this doesn't deal with everything. So this just deals with termination of the tenancy and other, it doesn't cover rent caps or what you can charge. So in the unincorporated county, the basic law is AB 1482. So you can pull up AB 1482 and it'll tell you when you can terminate and how you can terminate and what the regulations are. So there isn't one place like, here's a little book of everything in the county. It doesn't work that way. Let's go in the back with the glasses.
One question about the month-to-month tenancy. I'm trying to understand the drawbacks to going month-to-month. Okay, I listened to you about the 28 days. I got that.
Yep.
But what is the disadvantage in contractually obligating ourselves month-to-month?
What's the disadvantage of doing a month-to-month? If you do a month-to-month, you might not fall within this, you might not fall within this definition. I don't know how a judge is going to rule it. That's why I'm saying to make it safer, just do a 2-month or 3-month. Could you do a month-to-month and work out? Yes. But it's a lot cleaner argument. I can just point to this sentence and say, look, Your Honor, it's a 3-month lease. It's not a tenancy that's subject to this law, right? If we're doing a month-to-month, all of a sudden there's all sorts of weird arguments that might be made because the language is very not clear. Okay, let's see right here.
I have a question. If it's a Section 8 tenant, when you do their lease, it has to be for a year, so how would I do it 3 months at that point?
If it's a Section 8 tenancy and you have to do it for a year, how can I do a 3-month? Okay, well, you got to talk to Section 8, see if they're even willing to do something less. They might not. If they won't, then you got to think about, you can't now, as you guys know, you can't reject somebody who's on Section 8, right? So if somebody comes up, you know that, and they qualify, and they're the best qualified, right? Then you're stuck with the Section 8, and you're stuck with the 1 year if they're not willing to give you something shorter.
Do you have the names of the people who organized this?
Say it again?
Do you have the names of the people who created this?
Do I have the name of the people who passed this? Who created this? It's a city council, San Diego City Council.
The single family home, owner occupied with 2 separate units within the home, is that exempt or not?
Owner occupied house with 2 ADUs that are occupied, is it exempt? Yes.
2 separate kitchens and baths.
It's an ADU, additional dwelling unit, so it could be a separate structure.
It's not a separate structure, it's a single family home.
Okay, so it's a single family home and you're renting out bedrooms.
Part of it.
Yes, as long as it's 2 or less, it's exempt. So if you have a home and you're renting out 3 bedrooms, it's not exempt. If you're renting out 2 to 2 other tenants, it's exempt. Okay, people.
Does Section 8 fall under a government subsidy, or is that not part of your original?
Originally, on certain properties that this law does not apply to, it dealt with tax credit properties. Section 8 is not considered a tax credit property. Section 8 has its own instructions, okay, and certain federal laws apply to it, okay. So there's more laws that are going to apply because it's Section 8, and there's a federal payment, okay.
What's the benefit of cash for keys over? What is the benefit of doing it cash for keys?
The question is, what's the benefit of doing a cash for keys? Benefit of cash for keys, if it works, the tenant goes out without you filing an eviction. Right? So let's say if the tenant's behind 2 months rent and you're like, look, I'll waive your 2 months rent and I'll give you a month free if you move out, $2,000. When you give me the keys, the tenant moves out, you pay $2,000. Let's say you don't do that. You serve a notice, tenant doesn't move out. You call me up, I want to start an eviction. Great, I need X amount. It's going to start $1,500, whatever it is, cost and stuff, and it might take 10 months to kick them out. You're going to be out 10 months worth of rent. You might eventually get a judgment, but then the question is, are you going to be able to collect from this person? That's the benefit of doing cash for keys. You avoid
Is
it.
it better with COVID gone now, or we haven't progressed much, huh?
Say again?
With the time frames that the sheriff, I went through that.
Is it getting better? Is it getting better time frames now that COVID's a little bit further difference with the court? About a month ago, we got a new judge. Just so you guys know, in the county of San Diego, there used to be 4 courthouses. There still is, but Vista, El Cajon, San Diego, and Chula Vista. And you were able to process evictions in all 4 courthouses. About 10 years ago, they reduced it to just Vista and San Diego. About 4 or 5 years ago, they reduced it to 1 courthouse in San Diego. What that means is every single eviction in the county of San Diego for 4.5 million people all gets processed in the downtown courthouse in one department, Department 501. Every morning calendar, so they have a morning calendar, afternoon calendar, they probably handle about 25 trials that are supposed to happen in a 3-hour period in the morning and a 3-hour period in the afternoon. They can't do that. If any trial is supposed to last longer than 15 minutes, they'll try to farm it out to a different department, some other judge. Hopefully that judge is able to listen to you. If they're not able to listen to you right then and there, they're going to bump you to a different day, right? In that department, the only reason it kind of works right now is because a lot of the attorneys have worked together for a very long time, and they settle a lot of the cases. So I would say I settle 50, 60, 70% of the cases. So if I settle a case, the judge just basically has to hear from us for a couple of minutes. Hey, Your Honor, we settled the case. Great. Submit the case to me so I can get it signed, and we're done with your case. They don't have to hear a trial. But if the attorneys didn't do that, and all of a sudden you have 25 trials every morning and every afternoon, it would be a complete nightmare. So, the attorneys are really trying to keep things moving forward. Things have gotten a little bit better with the new judge. The new judge realizes that things have been horrendous. I'm sure the presiding judge of the Superior Court, who is a judge, as well as this person is responsible for the operation of the courthouse, has gotten an earful from people like you and other people's like, why is it taking 5 months to get my paperwork processed? So things are getting a little bit better. So I have hope that things will keep getting better because the judge and presiding, I believe, really understands that this is becoming a nightmare for you guys and for us. Before I would handle cases, 90% of the cases would be solved within 2 to 3 months, right? You get possession back. Now I have cases from June, July of 2022. I'm still hanging on to. I'm not hanging on to them. I want to be done. I'm just waiting for the writ or waiting for the sheriff. If there's any hiccup in the process, it adds 2 or 3 months. It's just I'll explain a hiccup. Normally, let's say you're 1 month behind in the rent, and we file an eviction. Okay, 1 month. We would submit the case as being a case below $10,000. Okay, because it's only 1 month, $2,700. But because things were taking so long, all of a sudden the amount of money that's owed was over $10,000, right? $12,000, $15,000, $20,000, because it took so long. All of a sudden, we filed under $10,000 thinking back then, well, we're not going to get above $10,000 because the filing fee for less than $10,000 is less than if your filing fee between $10,000 and $25,000, what your judgment is going to be. All of a sudden, it's like, we need to reclassify the case. Well, typically, what we do in a stipulation, if you have a stipulation, is like the parties agree to reclassify this to between $10,000 and $25,000. And here's our additional fee. The court would process it. The clerk's office would process it. Under the old judge, he's like, no, that's not sufficient. Why is it not sufficient? If all the parties, plaintiffs and defendants, agree to reclassify it, the court has additional payment. No, we're not letting you do that. They forced me to set up a hearing, to go in front of a judge, to basically say, Your Honor, I want to reclassify this case to between $10,000 to $25,000. The judge ordered it. Now remember, on a stipulation, the parties sign it, and the judge signs it as well, making it the order of the court. So I was there in front of Judge Bell, and I'm like, Judge Bell, when you sign the stipulation, it's an order from you. All the parties agree that we can reclassify it. Why can't we just, well, no, I understand that, but you need to come in. Set up a hearing, takes a month, go in front of the judge, Your Honor, blah, 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 here's what happened. It was under $10,000, this took 8 months, now we're over $10,000, I want to reclassify. Great, I'll reclassify, I'm ordering it. Great, then I resubmit the stipulation, resubmit the fee, and we lost 2 months. Now when the court gets the check, it gets even worse. The court gets the check and says, hey, the judge approved this, why aren't you cashing the check? We don't know how to handle those checks yet. What do you mean you don't know how to handle these checks yet? The judge agrees to the reclassification, we understand, but we still haven't gotten instructions of how to handle this additional payment. I lose another month, 45 days, and the clerk's office figures out how to handle an additional payment on an order that the judge already ordered. So I burned 3 months, right, trying to reclassify something, which in the past, I would put in the stipulation, right? If we went to trial, at trial I would say, Your Honor, I'd like to reclassify it and do it right then and there, and the judge says, okay. With the stipulation, all the parties are signing it. There's nobody being harmed here, right? We're not trying to pull a fast one. The judge signs it, and next to his name it says, it is so ordered. Telling the clerk, I agree to the reclass. No, we can't do that. So it's just, we're fighting constantly with the clerk. In the past, if there was a problem with the case, I would call the clerk, hey, blah, 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 can I talk to a supervisor? Eventually, a supervisor calls me back a day or two. Hey, what's the problem? Look, the clerk kicked back this paperwork. They shouldn't have kicked the paperwork. They made a mistake. Supervisor looks at, you're right, they screwed up. The clerk's office screwed up. We'll fix it and we'll get it processed. That's how it should work. Nowadays, we call up, hey, I want to talk to a supervisor because there's a problem with it. I don't get calls back anymore, right? They're just not calling me back. I'm to the point of sending my paralegals to the front office physically, so hoping that they can actually talk to a supervisor saying, look, this case is messed up. And what's happening is all the cases are messed up. Everybody wants to talk to a supervisor, and supervisor are getting overwhelmed. They can't call us back. But again, we're just sitting here. But recently, to give you guys some hope, I've been getting sporadic writs back from the court, right? Some are still taking 6 months, but hey, I just got one back in 2 months. I don't know why this took 2 months and why this took 6 months. So I think what's happening is the new judge is coming in and processing things quicker, right? And the old stuff might be stuck on somebody's desk, and eventually they get to it. So there's kind of some cases get heard or processed faster than others, and it's just a nightmare.
Hire more people. I mean, we're talking millions and millions of dollars that we're losing because of this ridiculous.
Why didn't they hire more people? This is what happened during COVID. My understanding is a lot of clerks quit or didn't come back. They hired a bunch of new people. At the same time, during COVID, they passed, not including this one, they passed 17 new laws affecting the relationship between landlords and tenants. 17. Whenever you pass a new law, people need to understand it, the judges and the clerks. Some of these new laws required new forms, right? Hey, from now on, the law says X, Y, and Z. Well, the old forms didn't have X, Y, and Z. They need to work up a new form. It takes them 2 months to work up a new form. They work up the form, they don't tell us. We submit paperwork, and all of a sudden it's like, no, this is kicked. Why? Because you don't have this new form. You never gave us the new form. Here, okay, so we resubmit with the new form. They won't tell you how to fill out the new form. You have to guess how to do it, right? We look at it. It's a lot of times it's not clear. I think we check off this. I think we say this here. And of course, they won't tell us on the phone. And it either works or it gets kicked. No, you should have checked off this other box, not that box. Okay, we'll do that. Or hey, you checked out, or hey, the clerk doesn't know how the new form works. So we did it one way with one clerk. They okayed it. Exact same way, exact same type of case with the new clerk, they kicked it. What do we do? I don't know. It's a nightmare, right? So I think the clerks are starting to get better, starting to understand things. It's frustrating for us because we know how things should be processed. They're not getting processed correctly. You don't want to upset the clerk too much because then your cases end up at the bottom of the pile. So we always have to be nice and respectful, and we're always nice and respectful. They have a tough job. But eventually they need to speed up this. Okay, the question is, okay, the question is, well, if you don't fall under this law, and 1482, which is the state law, has a just cause and a rent cap, do you fall under 1482? No, there's only one set of laws. If the city passes an ordinance, like San Diego does, the state law does not apply. You're just dealing with the San Diego law. So if the San Diego applies and it doesn't apply to your tenancy, you don't go to the state law, it doesn't apply, and you can just treat it as a tenancy that the new law doesn't apply to. You don't apply the state law. Does that make sense? Okay.
As the AOA forms with the new 2-month lease, as well as the addendum that we need to give everybody been updated yet?
I don't think well, remember, you can take the current rental agreement from AOA and just make it a 2-month lease, a 3-month lease, right? With the disclosures, I believe they have the basic disclosures. I kind of reviewed it for them yesterday or today. And it's not too tough. I mean, there's certain language there. I believe they have those notices, right?
They're in process.
They're in process.
They were trying to get it procurement to get enough approval.
Right. So the basic notices, I think they'll probably be ready in a couple days. The exemption notice and the notice that the law applies. Okay, we're doing good.
Frank, a couple of comments. One, I heard one interpretation that because we now have our old law, that the state rent cap law.
No, I didn't say that.
Not you. I heard another interpretation. May be at risk of enforcement. I'm just saying this is what somebody else is.
So you said somebody else told you that this.
I heard it. A legal opinion, different opinion.
Saying what?
That the state, the rent cap would not be as enforceable because now San Diego has its own law.
Okay, so the statement is, you heard that maybe the rent cap, the state rent cap law might not be as applicable because San Diego passed this law. That's not right. This law that has nothing to do with rent caps, okay? The state law deals with rent caps. The city law did not supplant the state law because this doesn't cover rent caps. Does that make sense? So just because they did a portion of the law they've covered doesn't mean, well, all state laws now don't apply. I'm not saying that. Dealing with termination, relocation benefits, buyout agreements, this applies. Rent cap, I didn't talk anything about rent caps, right? The state law applies.
Well, second question,
Wow.
I want to answer, I might have missed this, but as far as any notices that were given prior to June 24th, what's the retroactively?
You know, I was waiting for this question. So what if you gave a notice prior to June 24th? Is it retroactive or not? The law, there's nothing in the law that says anything that this is retroactive, okay? So I always like to be conservative and if we can do a new notice, let's just do a new notice. If we're already farther along, so let's say you just served a 3-day notice. Well, 3 days doesn't matter. Let's say you served a 60-day notice for substantial remodeling and it expired last month, June 1st, before the law. Can I file an eviction and win on it? I don't know. Do you want to take the chance? I don't know, right? We can say, you know what, Franco, let's push it, let's do it. Okay, let's do it, right? I'll argue it's not retroactive, right? And we should be able to move forward because of X, Y, and Z. You know what the argument is going to be on the other side. Well, Your Honor, it's June 25th, 24th. They haven't filed an eviction yet, right? When you filed an eviction, it was after the law was in place, and so the law should apply. Then it's going to be up to the judge, right? So the safe route is let's just do a new notice, let's just apply all the laws, and let's move forward, right? And I say that because, you know, if the whole process took 2 or 3 months, okay, great, let's go on the old notice and let's take a shot. But if you're going through 8 months to find out your notice isn't good, and we have to start all over again, I don't know if that's you know, I don't know if you want to risk that, right? So I'm willing to take a shot, but of course, if you came to me and say, look, I want to take a shot, great. I would tell you, I don't know if this is going to work. We'll give it a shot. If it doesn't work, it's not my fault, but you wanted to give it a shot. If it works, great, right?
You mentioned that there's some different laws that apply if you have a loan on a property that's got some finance, some federal subsidized. Can you touch on that a bit?
Earlier, I made a statement that a type of loan that you might have on a property might affect what type of notice you have to give. And typically, if it's a federal type loan, Fannie Mae loan or something like that, there's different requirements because certain federal laws apply. So when we take on a case, one of the questions is, again, what city are you in? What type of property is it? And is it a federally backed mortgage? A federally backed mortgage. So it could be, hey, I got the loan from San Diego Credit Union. Okay, but that might be a loan that's backed by the federal government. There's a website that we can check. So we go on that website and we actually check what type of loan you have on that property, and it'll tell us if it's a federally backed loan. If it's a federally backed loan, then the time periods of the notices will change.
So is this the same, like Fannie and Freddie in the secondary market, you know, they go and buy a lot of the loans that are originated by like a VFA or something. Are these the same kind of loans?
So Fannie Mae and Freddie Mac they sometimes buy securitized loans on the open market. Could that be something that's federally backed? I don't know. I don't want to guess. There's a website. We go to the website. If it tells us it's federally backed, we're going to follow what it says. I'm not going to fight the federal government, argue with them saying it does or does not.
Say you have 2 move-ins, one Section 8 tenant, one non-Section 8. For the Section 8, you have to do a year lease, and the other one you want to do a 3 months or less lease. They can't say you're discriminating.
If you have 2 tenants moving in and one is a 1-year lease and the other one isn't, well, no. With the Section 8, can they claim you're discriminating? Whenever you treat people differently, you're discriminating, right? The question is whether or not it's an illegal discrimination. I would argue it's not because you're not the one imposing the 1 year. Section 8 is. Normally you would do 2 or 3 months, right? So, and actually it's a benefit. Well, it's a benefit for the tenant to have a 1 year lease, right? So whenever you discern between two things, it's called discrimination, but not all discrimination is illegal. Does that make sense? Right? So let's say, hey, you have two tenants, right? Two potential tenants. One makes $5,000 a month, the other makes $4,000. You're picking the one with $5,000. Well, you're discriminating against the person with $4,000, right? You are. You're treating them differently. But it's not an illegal discrimination because you can discriminate on people's income on whether or not you want to rent to them. I think I'm going to do like 2 more questions, then we're going to go.
Is the presentation at your website?
Presentation on my website, you can go and scan the QR code and it'll download to your phone. So go on your camera and you'll download it. We'll have it available on my website as well. I'm going to do 2 more and that's it. This one and this person. Okay.
If you send a tenant an exempt for 1482, you still need to send an exempt for this new law.
If you send a notice that you're exempt from 1482, do you have to still do this? Now remember, this deals with the city of San Diego.
I know, but at that time, this wasn't the law.
That's fine. But if you're in the city of San Diego and this applies, do you need to do an exemption of 1482? No, because the state law doesn't apply. So in the city of San Diego, if this applies, you need to follow these rules. One last question.
I just signed up some students prior to June 24th for a lease starting in September when school starts. It's a month-to-month lease. And it says it's a month-to-month lease, but it will not go past next month, May 2024 unless we mutually agree to it. Do I need to send out all this protection stuff to them?
So you have an executed lease with people that are going to start in November.
They'll start in September when school starts.
Okay, so you have a lease, City of San Diego. You're not exempt. Let's assume you're not exempt. The law applies to you. You need to follow the law. I thought you were going to ask the question, should I go back and enter into a new lease for 3 months and renewed? They haven't moved in yet.
But it's next month, it is less than 3 months.
Again, we're going to, I don't know whether or not month to month is going to be considered.
But if I have in there that this lease will terminate May 2024, no matter what, unless we both agree.
It doesn't matter.
That doesn't matter. So
No.
So the contract's not
You're day one. If it applies to you, the law applies day one of the lease. So as soon as they signed it, now it applies. Even though you signed it, all current leases, this law applies to the current leases if you're not exempt. Okay? So you have an old lease prior to the law, like just anybody else. Okay? You understand that?
I do, but I thought if we were 33 months or less, we would be exempt.
But you didn't say you were 3 months or less. You said you're on a month-to-month. So I don't know if in a month-to-month agreement if this law is going to apply or not. I don't know how the judge is going to rule on that.
I can terminate it after a month. So could they. It's a month-to-month lease, either one of us can get a notice.
That's right. But if the law applies, then if you want to terminate it, there's only certain ways you can terminate it, right? At fault or no fault. Relocation benefits, maybe, maybe not. Does that make sense? A month-to-month is not a fixed term lease. That's what I'm, right, there's a problem there. That's why I'm saying with the month-to-month agreement, I don't know the language that I showed you guys, if they're going to say this law doesn't apply to you. I suspect they're going to say it does apply because it's not a fixed term lease. Okay, that's why I'm saying if you want to make it nice and clean, do a 2 or 3 month fixed term lease. Because then you can argue it's not a month-to-month, it's a 2 months, and it falls specifically under the language that it's not a tenancy. Okay, I want to thank everybody for coming out. If you have any questions, you can come up real quick. I'll stay for a little bit.
Wow, so thankful for Franco Simone and everything that, just all that he brought us there. And if you have more questions, you can definitely call his office. And also want to say, if you are not an AOA member yet, go ahead and join. And you can join by going to aoausa.com. And you can sign up online, or you can call Victoria, call our main office, and we can get you signed up as well. And anyway, hope that this information is helpful and helps you avoid headaches. Take care.